Hey guys, so I wanted to let you guys know what's going to be going on with the hearing, what to expect. And today I prepped for the hearing because Monday I won't be around. So Tuesday is when the hearing takes place. It's 3:30 Central Time, 1:30 Western, and 4:30 Eastern. So what will happen is we may not be the first case heard, so it might be like a whole hour before we're heard. And as soon as I do actually have an outcome, I will leave at least a little community post, but I won't really have the answer for everything in detail to you guys until the next day. I thought I'd do a live stream and go over everything that happens on Wednesday night. So, but for now, I just kind of want people to know what to expect and what we would do going forward. So, basically, what will happen is the judge will come in with now a really clear, preconceived idea based on everything that he's looked at on what he thinks about the whole case, not just the Demerara hearing, but even the case itself, because they will read the petition, and he already had read quite a bit of it. I think that had a lot to do with why he did what he did, but he wasn't sure on their authorities and points for throwing my case out. That was the part he wasn't sure about. He also wanted to know if we wanted to bring forward anything else, and I did. So, and I'm really glad that I did, because the case law that was found is very good. So what he'll do is he'll probably allow us to make statements and go over things, and then he will have his questions that he wants to ask. And one of three things can happen. Either he's going to uphold everything that I want and grant me relief on all points, or he's not going to do that. He's going to grant for going forward with litigation, which would be great. And I think that would be the most likely good outcome, more likely than the first thing, because granting relief on all points without first bringing the facts to light is unlikely. So, but it would be wonderful, wouldn't it? But litigating would be great as well. And the other options are dismissed with prejudice, meaning you can't bring it in that court or any other court. If that were to happen, I would appeal, and during the appeal, it would go to a higher court. And if I lost, we couldn't bring it forward. And if I won, then it would go on. But the other option would be dismissed without prejudice, which means they would allow me to amend the petition, and then we would see from there. So these are all the outcomes that could happen, and likely it's going to be about a 30-minute to 1 hour process. So I wanted to go over some of the aspects of the case, because first of all, like I know I try to explain things as well as I can, and I'm really amazed by people's ability to understand these complex topics because they care so much about the case, and they're willing to invest the time, and even people that aren't into law, in really understanding. A lot of people have a really astute understanding of everything, and I appreciate that so much. And it makes me feel good. It makes me feel like I explained it well enough. But it's not my forte necessarily to teach some of this stuff. And it's like if I was asking a mechanic questions, there's so much I don't know that they may be explaining it perfectly well in their mind, but I don't understand a lot of what they're talking about. So it's that kind of thing. They do it all the time, and they know what they're talking about. And the flip side of this is, some of this I may not be explaining the best way, but just doing my best here. So I want to go over kind of what the points are. What I did today was, I'll have my actual documents on one PC, but then I have notes. So, and the notes give me an overview of what all my main arguments are, the points of the Demerara, and where my case law is, and how it ties in, because now we're talking about having, multiple documents. You have your supportive brief with all your case law, and case law also within the petition and within the objection to the Demerara. So first of all, what is all this? Let me talk about that real briefly for people that might, hop in onto this topic someday and they just see this video and they wouldn't know what I'm talking about. So this case is a matter of public interest. It's a public interest case. So think about a lawsuit, and usually you have to have a personal stake in the case. So it has to be, I was harmed in some way personally, and I'm filing a suit. But this type of a case, a mandamus action, is it's a public interest case for a public's right to relief. And usually that type of a case is filed against a government entity. So a government entity that has a duty towards the public to do something, and they're not doing it. So you don't have to be personally harmed, but you just say, this is a duty they owe all of us, and they're not doing it. So we ask that the court make them do it. So you say, well, gosh, but you're suing a corporation, and I'm suing YouTube and their parent company, Google, in a mandamus action to compel the action. Now, what am I trying to compel them to do? I'm trying to compel them to turn into wanted fugitives who are promoting child sex abuse, who were already banned and are raising money in scams, defrauding the public, and who are wanted also for terrorism against a child. Those are the reasons I'm trying to compel the action. I'm not the child they tried to harm. I'm not molested by these people. They didn't try to kill me, but and I wasn't defrauded by them personally. So this was the way that I could, after trying from June, July, August, September, and into October to get their attention, none of that worked. So another thing about a mandamus action is you have to prove up that you tried and exhausted all your other remedies. So I did that. I literally did everything you can do. And then this was the last course of action. I then also can prove up that I tried to negotiate with the corporation and take everything but deplatforming one of the fugitives off the table. And they wouldn't be amenable even to doing that. So once you prove all that up, then the court should consider helping you, basically, because you tried to help yourself, didn't you? You tried to do this without involving the court. Now, do I have a right to relief? The demurrer is something that was filed by the corporation because they're going to say, you don't have any right to relief here. You're owed no duty of care for relief. You can't state a cause of action. So these are the things, and they have 8 points. So I'm going to combat them on all 8. And let me explain what they are. So just briefly. So number 1, they want to say that I don't have facts sufficient enough to bring a cause of action for a mandamus action at all because I'm not entitled to any relief based on what this is about. So this is about deplatforming people off social media. But what makes this case unique that gives me a relief and makes them acting like a government entity are several things. One is the child sex abuse material. So I have to prove up that they need or they have a duty to act as a government entity when it comes to child sex abuse material. And even better, if I can prove up that they already have. Well, I can prove both. So they are obligated to act in compliance with laws that already exist and serve as a public function and related to child sex abuse. And we can go over what all of those laws are, 18 U.S. Code Section 2258A, on and on I can go, the PROTECT Act, etc. But you suffice to say, you know what I'm saying. And they already act in that capacity. Google and the ICMEC do. And the CFAA match technology that Google uses, you don't have to have images of actual sexual abuse of children. Just the fact that they do that means that they are in the business of reporting to these government agencies child sex abuse material. And they also have specialized review teams related to child sex abuse material. Now, what am I talking about, child sex abuse? Well, Gatis Lagzdins, when he was CFAA, promoted incest. He has now taken his incest natural video off of Rumble, which was a YouTube re-upload from his banned channel, and it's part of my case. But that won't matter, Gatis, because, the court already saw it. The judge already read my petition. So going into the first demurrer hearing, he's read that. So he already knows about the video, and that videographic evidence is, reiterated throughout multiple of my hyperlinks and videographic evidence that was presented already in the petition. So they're going to be aware that you were promoting that as CFAA. Also, your CFAA Telegram promotes it right now, and there's a link to that on YouTube. Now, you're not allowed to link to child sex abuse material. This also is an issue. But part of that issue, and they're going to argue back and forth, they're going to say, well, we're not responsible for what's in a link. And my argument back will be, no, not before you know about it. But once a third party makes you aware, yes, you are. And that is the law. So that's how that's going to go. And we'll just see what they say. The part 2 of this is, can I bring a cause of action because of Section 230? Does that bar my action? And what is Section 230? Section 230 of the Communications and Decency Act. So that Communications and Decency Act was a larger body of law. And that a lot of that was done away with because it was just so far reaching. People didn't want to have, that much regulation going on with social media. So, and I think that's probably correct. But one thing they held on to was Section 230. Section 230 is what gives platforms like YouTube the ability to have no liability or low liability for the acts of third-party content creators. And that makes sense. I agree with that because, if you want to have the freedom to just quickly upload a video without having somebody having to approve it, That's part of living in a free society, some modicum of trust of each other. We trust people to make content responsibly until we see something otherwise. And also, we don't want companies to not want to give people those freedoms because they're paying out the wazoo for things people do they can't know about. Millions of people making videos, you could never know. You could upload a video today where you murder somebody and then you put it online and they can't know, that you're going to do that. So obviously there has to be some limit to the liability. But we also live in a world where, we have responsibilities towards each other. We want to live in a world with basic decency where we don't aid and abet certain things, especially crimes against children. So that being said, we have enacted things that make it where Section 230 no longer bars an action, or an action is no longer barred by Section 230 if you do these certain things, like child sex abuse promotion, anything related to terroristically threatening or harming a child, and scams, defrauding the public. So those are the things that namely, and this case has all three. So we have Gatis Lagzdins, also not just Asperia doing this stuff, but in his April 2023 live stream, that violates something called the SESTA Act. And the company is a mandated reporter under 18 U.S. Code, the section I mentioned before. That takes the Section 230 protections away. Failure to warn others regarding scams, that also removes Section 230. So you have a right as a member of the public not to be scammed. And that's another public interest type of thing. I wasn't scammed. I never sent him any money. And failure to warn the public is also part of this, regarding the scams. The public has a right not to be defrauded in scams, and the platform has liability once they're aware. Once they're aware, if they go ahead and play host to scams, that's the problem. There's a point at which they were not aware, but there's a point at which they are. So their third point against me would be that I can't bring a cause of action under the ATA. That's the Anti-Terrorism Act. So I say courts can hold corporations liable for aiding and abetting acts of international terrorism, which is what the ATA says. So I have to prove up a cause of action, and basically page 22 and 23 up to page 24 of my objection to the demo covers all of that. It's a very involved thing. It really could go either way on that. But once they're aware of, part of that is direct threats to U.S. nationals. Now, that could be the key where I don't win on that point. Because, Gatis Lagzdins isn't particularly terroristically threatening U.S. nationals, but is his presence being a terroristic threatener of a child a threat to us? There are people that might end up involving themselves with him, and he seems to be a very dangerous, wanted individual. So I can say that maybe it does. And also his number one fan, Prussian Society of America, is terroristically threatening other people over the guy. And he's also on using Google services and YouTube, part of his Unalive All Women movement. That's slapped on his page right now. Yeah, I don't know, I think that sounds pretty threatening, especially since I've now been directly named in several posts as someone who should have bad misfortune because of the case. So, but he's not a third-party defendant, but he is now part of the case because in my amended petition, I put all of the batshit crazy stuff that he posts on Google and YouTube about Luna and about myself now and about Sarah Norman, and all on behalf of Goatis. So these are psychos, and they're, turning a blind eye to terroristic threats. And it's related to this case now. So that's part of it as well. And they're required under the ATA to prevent things like this. Causes of action, their number 4 point. Do I have a cause of action for the violation of the anti-terrorism statutes? So those have to do with material support and also knowledge and intent of the intent to support someone who is doing terroristic crime. So Gatis Lagzdins is wanted, for any who don't know, for hiring somebody to firebomb his son and his son's bedroom, and he was a baby. So that's a terroristic crime against a child, and they did it twice. They weren't successful in killing the little boy because they weren't home when the second fire that was successful occurred. So that's terroristic crime against a child, and they've been made aware of the warrant. They've been made aware of all of the evidence. They've been made aware of the former ban. They, and we have ample evidence. This isn't just some speculative gossip session that people are having about the guy. In fact, he said plenty right in our face. He doesn't consider his son to exist, he said. He says he only has one child, not two. Along with all of the testimony of Ilias, which is now a matter of public record, saying that he was hired by Gatis Lagzdins to commit these crimes. And in the Netherlands, here's another problem. There's always some little glitch. you can't write about people who are public figures using their name because of privacy laws and certain laws that have to do with the right to privacy and your reputation. So those laws that have to do with the right to maintain your reputation make it where they only write about Gatis and Marina with identifiers. So the company, I'm sure, will try to say, but they weren't really written about in media, not directly. But I'd like to know who else is a Latvian raw meat cult YouTuber with a girlfriend who's married to Ilyas Abdullah. I think there's only one guy that fits that bill, and it's Gatis Lagzdins. But anyway, they didn't directly name them. They used like the initials and other identifiers, but generally, it's not going to be too hard to prove up that they were writing about them. Another thing to note about a Demerara hearing is that it will be assumed that all facts that I present are indeed facts, so we don't have to go into the ins and outs of whether they're facts or not. So these things I'm currently talking about, that would be part of litigating later. But for the Demerara hearing, it's just going to be assumed that they're facts. So assuming that Ilyas Abdullah said that Gatis Lagzdins was the person who hired him as the hitman against this child and the mother of the child, that would be enough to fit the bill for, a terroristic crime against a child and him being wanted for that and then being made aware. So another thing I should bring up here too also is because, I don't know how this is going to go with this also, is that they could argue, well, we don't have to know that that warrant's real or not. What if people gave us fake warrants all day? What are we, an investigative agency, And they might do that. And of course, I know that they will do that. But I'm going to argue that if it's involving any of these types of crimes, I think it is on them to check when they've been given ample evidence. So we'll see what the judge says. So point 5 is the CFAA, or the Computer Fraud and Abuse Act, and that's going to be knowingly allowing users to be defrauded of their services. So, we all have a contract. As soon as we have a Gmail, we use YouTube, whatever, we are contract holders. There are also people who are shareholders who have voiced their opinions on my petition. That has weighed if they would actually withdraw their shares due to not wanting to support this type of crime. That could really go a long way in bending someone's ear. But they at least have made their voices heard for sure. And recklessly causing damage, that's on page 29 of my objection. That's an important part of the CFAA being violated. Are they recklessly causing damage? Well, they're going to argue that it's not reckless. But when they are willing to go into an investigative period with me and claim that they're investigating all of this stuff, and then they don't even know how to say Sferia, and then they don't really look into my claims heavily, but they just look at liability issues heavily, cause of action, and double checking on that, and not really double checking on any of these serious crime-related facts, I would say that's reckless when you're talking about endangering children. So, just my opinion. And the opinion of thousands of people. Okay, point 6 is going to be, do I have a cause of action for the criminal statutes that I used? So the criminal statutes were not part of my cause of action, which I've made clear in my reply to all of this. But they are used because when you combine them with 18 U.S. Code Section 2258A, they give a private person a right of action. When you add the ATA, the CFAA, and all of that stuff, the private right of action is implied. And that can be argued that because what's implied? Meaning that it's to protect children from exploitation, the CSA stuff. So a private right of action to make them do that is implied. So that's what I'm arguing there. And also, you got to realize that we're dealing with, a mandamus action being a, like I said, public interest type of case, not a personal one. But the right of action is implied for a private citizen to do so in the broader interpretation of the statute. So once again, we'll just see when that's argued back and forth how that goes. But the criminal statutes are not part of me claiming that they're part of my private right to action because I'm not a victim of the crimes. It's a implied right for the public, if that makes sense, and hopefully it does. Seventh point that they make is they state that my petition doesn't state facts sufficient enough to state a cause of action for 15 U.S. Code Section 45. And that has to do with the Federal Trade Commission Act, which is that has to do with fairness and unfair methods of competition. So when you're on social media and you are a contract holder like we are, is it unfair what Gatis has been able to do to us as members of the public and as other contract holders? So let's see. How many of you have 2 channels, one of which you use to intimidate witnesses by sharing links to go find nude photos of them obtained under duress, by the way, and also the addresses, social security numbers, names, business addresses, and everything else of all of their family members who you threatened. You suggested that your followers should show them a bloody good time, and you defamed the person, even though that person wasn't the best person. She was being lied about there, claiming that the reason they should hate her is stuff she's done to Gatis, supposedly. We're talking about Catherine, his, at the time, wife that had left him. You know, done to her so that she wouldn't tell what she told. A year after the acid attack, the stuff she told and sworn to in an affidavit, this was revenge against her. We have him going on a live stream prior to that, doxing Diane and her entire family, and making defamatory, disgusting remarks about her for crimes she's never been charged for to this day. He's never gotten a lawyer to do anything about it to this day. But she supposedly was such a terrible person, he told them to go and contact law enforcement agencies about her. And some of them did that. So these are all crimes. And that's a drop in the bucket. So, and the child sex abuse material promotion and all of that. If you did any of that, and then you had another channel where you were actually still running scams directed at the victim of another crime you've done to them, where you attempted to kill them 3 times, do you think you'd have a channel? Do you think it's unfair that people I've talked to have told me they've lost their channels for talking about the jab? And I mean, lost their channel as soon as they did it. They made a video. That video went down and the channel went down. That's what one person told me happened to their channel over that. There are people that have had copyright infringement, or they've gotten a little too sexual, adults, like consensual stuff, but it's been just a little bit too far. All these kinds of things have been handled really punitively. Political things handled really punitively. But we've got a guy doing this kind of crime, and he has a second channel. And all we did was kindly bring it to their attention that they could be aiding and abetting a wanted fugitive who's wanted for trying to unalive a child who now lives in hiding, and maybe molesting one that's with him right now because he believes that's okay. Could you maybe not let him do that on your platform since he was already banned? And yet they go to these links where they hire a multi-billion-dollar law firm and pay them hundreds per hour to battle doing that. That's because, in my opinion, and let's get really real, I think they think Diane, they know that Diane could bring a case up to 2028 would be her statute of limitations on the first channel and all the crap he did there. So they're worried about all of that. Otherwise, they would probably not be acting this way. So that's just my opinion. The point 8 on this is going to be that they make against my case would be causes of action not being clear for the criminal statutes that I use, some additional ones. So let me explain that. The crimes that are being committed, I'm not making a cause of action, so they're just feigning confusion there. I made it really clear. I'm citing that those crimes are being committed and that other people have been held criminally liable that own companies, including social media and tech companies, for the very same crimes. They can be pursued by the Department of Justice for those crimes. And that ties into proving up that these are things that are regulated. So the court should mandate the action in the commission of these crimes, telling them that you can't continue doing this. That's the point of the criminal statutes. And, it's things like, statutes that have to do with using chemical weapons, helping somebody obtain money to use chemical weapons against someone, helping them defraud people in scams, helping people do anything related to committing child sex abuse or promoting it. There are criminal statutes governing all of that. And even the comments about, where he likes to get his human trafficking on, that's on the current channel, have to do with some of that. So that's what that's about. And then I have a ton of good case law related to all of this. The best 2 cases are Doe versus MySpace and Gonzalez versus Google. So that's the gist of it. Hopefully everything will go well. It's really kind of stressful, but I'm actually less stressed than I thought I'd be. I'm happy to be getting this part over with. And I've kind of come to terms with the fact that a lot of things don't go the way that they should. And I'm no longer freaked out by that. I always knew that, but it really is disheartening to see people lie like this, and you don't know why they would even want to. It really does floor me that anyone could be that evil, even on behalf of a corporation. It's just weird to me, emotionally weird to me, that anybody could gear themselves up to go and battle me on not protecting the kids. It's just bizarre, and it makes me upset. It makes me angry, and it makes me sad. But at the same time, I know what I'm doing is the righteous side of stuff, so I am happy to do it. There's some stress also with the outcome, how much it could affect people, and their lives, and even mine at this point. I'd like to be done with this, and I'd also like to not be at risk myself. So I would appreciate this coming to an end, but I want it to come to the right end. So even if it doesn't, the good thing is that we're keeping eyes on it, and we're eventually going to get the right eyes on it, and that will motivate something to happen. The longer it goes on, the more likely either media could pick it up at some point and be like, what in the hell is this weirdness, and you can't be serious that they weren't willing to take him off of there. It furthers the ability for the public to see it and get more and more angry, and just the right people getting angry, people with some power. And I also do have some other ideas on how to do activism related to this, and there are other people doing things as well that could be the thing that does it. And another thing I want to bring up that reminds me of, law enforcement not doing their job does not negate that these people should do theirs. A lot of people are, and they're going to do this in court. They're going to be like, well, this is law enforcement's job. And look at all the people she reached out to. They're going to say that. Like, she reached out to the TCO entities in Europe. She reached out to Latvia. She reached out to Germany, the Bundeskriminalamt in Germany. And she reached out to the Netherlands and this and that. And I got responses from both Latvia and the Netherlands. But the thing is as a third party, by way of law, they don't have to tell me what they are or are not doing in this situation. So I did report those things. Even if they don't do right, and even if they're subject to something for that, that could be done by people, that has nothing to do. That doesn't negate the responsibility of the social media company in my country to uphold our laws as they apply here. So that's what we're trying to get them to do. Hopefully we can do it. And then there are other things that can be done along the way. I would love to see, this come to a head, but I know we're having a dent in his ability to get viewers and them not know about this stuff, which is, of course, putting a dent in his pocketbook, which every dime that he can't get his hands on is a dime that might stop some of this. So that's good. And I'll tell you what else. That fake letter, most likely fake letter that he sent to Gone, the Ghost of James Uganda did that video this past week about that. That situation proves up that no one's defaming him, to any fans that might actually believe that, that don't know all of this stuff and just might happen upon a video. So if anybody had defamed him, they sent a cease and desist letter to Diane and gave her an outline for what she was to do and to take down. And if she didn't, they would be suing. Well, they would be suing. They'd be suing me as well. They'd be suing everybody who said any of this stuff. So that brings me to another issue about defamation, which is really interesting. One of the first things I did was sort of tease them in one of my videos about, I had Marina saying, I'm going to sue you for defamation. Let me look it up, and then I had her looking it up and saying, oh, damn it, I'm actually guilty of this shit. I can't really sue anybody. So that's the reality. They don't have a defamation suit. And for any fans that might, happen upon like this video or whatever and not know all the ins and outs and think it might be somebody being defamed. Nuh-uh. So we've put a dent in his pocketbook. Jake did for years with his parody videos. That was already getting people being like, what? Vegan Gains, they'd see a video. And then, all the different people talking about Goatis and what he's been doing, that gives people the alternative viewpoint that, they can see what he's actually been doing. And then you have now he's done so much more, and there are so many more people talking about it. If these were defamatory statements, with the way the laws are in Europe, which are very much, it would be very easy to go after somebody that way if they were really being defamed. So Gatis Lagzdins and Marina Abdullah have been heard of now by more people than they would have by happenstance on their channels, by way of the Rotten Mango video, for example, with 2 million viewers. So now the first place people will hear about them will be people talking about these crimes and these things that they've done. So, if you were being lied on, I guarantee you that you would do something about it. They don't, because they can't. So that's how that goes. Anyways, just wish me luck. I will do my best, and hopefully this will have one of the better outcomes. And if not, we're still going to do stuff, both behind the scenes stuff unrelated to this and this. So eventually something will give, I do firmly believe, with regard to these people not being able to sustain themselves and being caught. So just stay vigilant, if you will, and please don't, stop having at least a reasonable amount of interest in the case, because, and by the case, I mean in the case of not just this case, but getting them caught. getting them stopped, finding their kid that they have with them that they're possibly abusing, and the one that they want to murder, letting him have a free life and his mother as well, without having to worry about where these people are. This is not like a situation where it's about just punishing someone for what they already did, but part of justice is that like people literally can't go on with their lives because of this properly. And and if you put enough pressure on people this stupid and people this inept, everything they did was badly done. And then they no longer have sources of funds like a net, and that's a whole nother can of worms that needs to be opened up at some point. The statute of limitations on some of that crime has not gone out in Germany yet. It's not expired. So, there's just a lot of stuff that can still be done, even if nothing pans out with this, and just along the way, keeping people aware, keeping people away from being scammed or involved with him is all important activism, whatever kind that you feel comfortable doing, of course, of your own accord, based on what you think makes sense for you. Definitely the more the merrier in trying to do something about something like this. So I appreciate it, and I will keep you guys posted on Wednesday about what happened, and I'll make a little post on Tuesday, and then Wednesday I'll tell you the ins and outs. Hopefully it'll be something celebratory. We'll see. Okay, everybody, have a good night. Bye-bye.